So after the reinstatement was denied in December 2022, this international student was freaking out, found our firm, and we filed a motion to reopen, saying to USCIS, please reopen this case, readjudicate it, and approve the case. It would destroy this student's life if their international student status is terminated because they would have unlawfully stayed here. This was one of the craziest cases, and we just got it approved. Without a request for evidence, USCIS just reopened the case and directly approved it. There were so many things that happened in this case. So let's dive into this, pick it apart, and see what we can learn. Let's go. Hi everyone, my name is Joseph. I'm the managing partner here at Tsang and Associates, where we solve legal problems with creative solutions. So the legal problem was that this F1 international student's reinstatement already got denied. When you file the reinstatement, you know something's already wrong, right? The student was already out of status. They got kicked out of school. Something terribly wrong has happened. There were at least 4 or 5 things that was devastating to this reinstatement case. So first, it's outside of the 5-month period. And that's always very difficult to explain. Why did you find out so late? What happened during this meantime? What did you do? The second issue was, are you continuing to study? Are you a real student, past, present, and future? After the denial in December of 2022, the client contacted us. We prepared this case within 1 month and we filed it. This was our motion to reopen, and we had to overcome all of those issues. The first 2 pages was the statement of facts, and this is what I learned in law school. The statement of facts is one of the most important things. In the way you state the facts, it can move the needle. And so in the statement of facts, we clearly show that in December was when the school officially reached out to the student, letting her know that her status was terminated. She didn't know beforehand. And so that moved the needle within the 5-month period. And then we talked about what the previous attorney did. And also the previous attorney was the one that advised her she could not go to school because she's out of status. That is true and not true at the same time. You cannot study if you don't have valid status, just like you can't work if you don't have valid status. However, if you're in the process of reinstating your F1 student status, you need to prove that you are continuing and currently studying. So it's only specific to reinstatement type people. So you entered as an F1 student, you were studying, and now your status got terminated. So it's best that you continue to study and prove that you are studying so you can get your status reinstated. So there's a continuity to your study. Most people don't know this, but that's what's required. So we had to explain that in the statement of facts, that the student was told that they could not study. So again, it's not her fault. The last thing though, and which in my opinion was the most difficult thing about this case, is why did she fall out of status in the first place, right? Well, I mean, if you're a normal student, you should just be studying, but what happened? And the thing was, she had eye problems and it was really hard for her to study, and so she fell out of status. Is that a good enough reason for USCIS? You know, I couldn't say it's the best reason. I didn't know if this was going to work. That's why this case was so hard, and we thought this case was going to be denied because of this. We filed that with a statement of facts. We provided all the explanation to the request for evidence and how everything we submitted are considered new evidence. And we provided reinstatement I-20, respondent's 907 payment for the SEVIS fee, a DSO's letter that's signed, and then her affidavit again explaining everything. Her transcripts again, her Chase bank statements showing that she's able to support herself, the pictures of her attending class, doctor's note about the eye problem, affidavit of her family talking about the situation, and then the consequence of denial if her case is denied and how everything is not her fault. In total, it's just 8 pages. Right? We didn't have a lot of time to go through and argue her case as we would like. Got all these documents, coordinated with the doctor's office, coordinated with the school, got everything that we wanted, filed it in March of 2023, and then now the case was approved. The client was overjoyed because she's been out of status since 2021. These past few years, on top of COVID, not being able to travel to see her family, has just been a big torment. She wanted to try to cross to Mexico to save her case, all sorts of things, but it just didn't work, and she was just stuck here in the US. One problem, a simple eye problem, led to all of these things, and it's just insane that it takes years and multiple attorneys to solve this problem. My biggest takeaway and encouragement is, don't treat these applications as if it's just collecting documents and sending it. Add the story, add the explanation, defend your innocence, and explain the consequence of denial, right? We wrote an 8-page motion to reopen, explaining her whole life, adding things that the USCIS didn't even request, like pictures, like resume, like bank statements, showing this is the person that you're kicking out of the country. They are doing everything they can to make a life here. They're working hard, and it was just this one little mistakes. Mistakes happen. It's human. But please, you have the power to adjudicate this case fairly and save this person's life. The case was approved, and I'm very happy to share this good news with you. If you have any questions, feel free to reach out. Take care. Bye-bye.